All right, here's your notes for Chapter 11 defenses. Again, in the United States, the court system, the prosecutor or the government has to prove beyond a reasonable doubt. So that's the burden of proof that they have to bring into the courtroom. They have to convince the jury 99% that the defendant is guilty. There's a bunch of different defenses you can bring to the courtroom. No crime could be committed. So you can say, you know what, this never happened. There was no criminal intent. Maybe there was no criminal state of mind. You accidentally did something. You took someone's umbrella from a restaurant that wasn't yours, thinking it was yours. Maybe a defendant did not commit the crime, so I wasn't there. There's no evidence against me. The alibi, I was somewhere else, maybe when it was committed. Defendant committed a criminal act, but the act was excusable or justifiable. So affirmative defense, self-defense, maybe defending your property, someone using reasonable force of some sort because they thought they were going to be harmed, they were in imminent danger. So this idea of reasonable force, reasonable non-deadly force can be used to protect your property. That's in your make my day laws, which give people the right to use deadly force to defend their property. So the difference here, self-defense laws require someone to use a reasonable degree of force against an imminent threat. The Make My Day law allows a resident to use any degree of force against an intruder to protect himself, other residents, or his property. Any occupant of a dwelling is justified in using any degree of physical force, including but not limited to deadly force, against another person who has made an unlawful entry into that dwelling, and when the occupant has a reasonable belief that such other person might use any physical force, no matter how slight, against any occupant of the dwelling. So some states like Texas, Colorado, and Oklahoma have those. Here's a quick story about self-defense. So in the afternoon of December 22nd, 1984, four African-American youths boarded an express subway train in the Bronx on a mission to rob video game machines in lower Manhattan. At about 1:40 in the afternoon, Bernhard Goetz, a slight eyeglass-wearing 36-year-old electronics engineer, entered the same downtown train at the 14th Street station in Manhattan. He, too, was on a mission. With around 20 other passengers in the car, Gates sat down across from the group of four. A few moments later, two of the four, Barry Allen and Troy Canty, arose and approached Gates. The other two, James Ramsey and Daryl Cabby, followed soon thereafter and soon surrounded Gates. Canty asked Gates for $5. Gates acted as if he didn't hear Canty and asked him to repeat himself. Canty responded, "Give me your money." Gates stood up, drew a .38 caliber Smith & Wesson, that's a gun, revolver from his jacket, and fired shots at the youths. All four were hit, and Cabby lay bleeding. Gates said, "You don't look too bad. Here's another." The last shot severed his spinal cord and left Cabby paralyzed. The conductor of the train heard the shots and pulled the emergency brake cord. The train came to a stop between stations. The conductor of the train heard the shots and pulled the emergency brake cord. The train came to a stop between stations. Gates managed to escape through the opening in the two cars and would not be seen again for over a week. After the shooting, Gates rented a car and fled to Vermont. If he thought people would forget about the shooting after a few weeks, he was wrong. Gates finally surrendered 9 days later to police in New Hampshire on New Year's Eve. So, if Gates were tried for assault, what would he have to establish? Would he be able to establish self-defense? Based on the facts, think about this. Do you believe it was self-defense? So, should the teenagers be charged? Again, they were approaching someone to commit a robbery. Should the citizens be allowed to carry guns? That's for self-defense. That's a whole other story. Eventually, Gates was acquitted, meaning found not guilty for attempted murder and assault. However, was found guilty of illegal possession of a deadly weapon. But we know that there is also a civil side. So, before the criminal case was over, Cabby, who had been paralyzed and partially brain damaged in the shooting, filed a civil suit against Gates. That was in 1985, and about 10 years later, a jury found that Gates had acted recklessly and deliberately inflicted emotional distress in Cabby and awarded him $43 million in damages, $18 million for past and future pain and suffering, and $25 in punitive damages. Shortly thereafter, Gates filed for bankruptcy. In such cases, the court would usually garnish take 10% of his wages for 20 years, but it's unlikely Cabby will ever see any of the money, as Medicaid has the first claim on income Gates receives. Or Cabby receives, sorry. All right, another defense. A defendant committed a criminal act but is not criminally responsible. So infancy child will be charged differently and go to the juvenile system. Or intoxication, you can claim you're too high or too drunk. However, you can still be found guilty. You just don't have responsibility, so you can still be sentenced. You can claim insanity. It's grown over the years. The accused do not know the difference between right and wrong. The legal definition of insanity: criminal defense asserting that at the time of the commission of the acts constituting the offense, the defendant, as a result of a severe mental disease or defect, was unable to appreciate, so he didn't appreciate the nature and quality of the wrongfulness of his act. A person is insane and is not responsible for criminal conduct if, at the time of such conduct, as a result of a severe mental disease or defect, he was unable to appreciate that nature. So it's grown. We know a lot more about mental health these days. They want to know if that person was mentally unstable at the time of the crime, before, after, during the trial. Another defense, entrapment. Defense applies when the defendant admits committing a wrongful act. I did it, but claims that he or she was induced or persuaded by someone of a law enforcement officer. They told them, they made them do it, and they did it because they were a law enforcement officer. Something out of duress is when a person does something because of the threat of immediate danger to life or personal safety. Talking about maybe dying on that boat and killing someone to eat them, or maybe someone attacking you. So necessity is when a person is compelled to react to a situation that is unavoidable. Someone's charging at you with a gun, trying to run you over with a car, so you reacted. So the Model Penal Code, one of the defining features is the way it defines crime. Model Penal Code has its standardization of the criminal mind to determine levels of mental state. This means that the law would take into effect or account a person's state of mind when deciding to prosecute. So this kind of looks at what is the mental state of that person. If it's out of necessity, what would their mental state be like at that time? All right, so that was your quick Chapter 11 notes.